Let's move to Nancy in Southfield. And she says, my sister is my mother's court-appointed guardian. The house is in my mother's name. Can my sister, as guardian, sign her name on a deed to me and my brothers? So I'm assuming she means, can my sister sign her mother's name on a deed, or would it be her own name?
Sounds like she wants her mother.
Okay. And the second part of the question says, also, my sister does not want to own the property. She would just be deeding the property from my mother's name into my siblings' names. Okay, so there we go. So as a court-appointed guardian, but what I'm noticing here is not power of attorney. Okay, so Nancy, what are her options here?
It's really interesting that you said no power of attorney. You know, if the sister who is acting as the guardian had a power of attorney, even the power of attorney you have to look at, okay? Because the power of attorney specifies what are the rights of the attorney in fact. That's the person you've relinquished control to perform whatever the functions are on behalf of an individual. They call that the attorney in fact. So we're kind of going off the aside just for a minute. That power of attorney, if there was a power of attorney, you have to first make sure that there's the authority to actually deed, mortgage, and convey property.
Okay.
It even goes one more step, and that is anytime you do anything related to a power of attorney and conveying property, that power of attorney actually has to be recorded in the county in which the property is situated.
Okay.
Okay. I know that's the aside, but you brought up power of attorney, and that's the first thing I'd say is, well, do they have a power of attorney? That's
the first question I would ask. So.
And they don't. Well, she didn't mention it. She's saying she wants to use the guardianship. So, well, the statute, there's probate law, the statute is going to allow, how do I say this? Oh, so if there's no conservator that's been appointed for the mother, and there's only the guardian, it's very likely that the guardian can execute a deed. However, I haven't seen, you know, I'm giving you general information. This is for educational purposes. Generally speaking, if somebody came to me, and she did with this type of question, I'd want to see a copy of the guardianship papers, the letter of authority, okay? Because the judge there may limit what that guardian could do, okay? So at this point, that question is kind of a little out there. Like, I can't give a definitive answer, but I'm leaning towards the answer, which is no, a deed itself will not do. Okay. I mean, the guardian papers won't allow the daughter to deed.
Yep, and that makes sense though, what you said, because the doctor can't diagnose you over the phone, and David can't give you legal, you know, definitive legal, you know,
well, that's a hard one,
here through email like this, you know. So,
but I do want to share with you, Blair, that it shows you how important it is to have the right documents to be able to do what you need to do. Because if you have this mother now has a guardian, this lady has a guardian, that implies that that lady is not capable of doing her own. She cannot deed on her own. There must be it's a mental lack of capacity, most likely. So how are they going to get this property into the children's name?
Right.
Could be problematic. The other issue that you mentioned at the end, it was like that last sentence that I picked up on, is she's the lady who asked the question, she said, my sister, who's a guardian, says she doesn't want anything to do with the property. So she just wants to do the deed. Here's what I tell people quite often when they stand to inherit property and they have a sibling or somebody in their family who's actually acting as a personal representative. The minute somebody says, I don't want the property, I'm not interested, get a quitclaim deed from them.
Okay.
Okay? Because that demonstrates they're not truly interested. They have no interest.